I'm Paulo J. Manaig and I will report the purpose and policy considerations. Primary objective. The main purpose of AM number 00407 SC, commonly referred to as the Rule on Examinations on a Child Witness, is to ensure that when a minor child is called to testify in court. Then we have three primary objectives. First one, the child's psychological and emotional well-being is protected. 2. The testimony is facilitated in a manner that is both just and effective. 3. The rights of all parties are balanced with the child's best interest. Then we go to underlying principles. Number 1, best interest of a child. Ito ay isang core and legal ethical principle used in family law, child protection, and custody decision. Then second one is the child-friendly procedures. Ito yung mga patakaran na idinisenyo upang matiyak na mga bata ay tratuhin ng may dignidad, paggalang o pagiging sensitibo kapag sila ay naipag-ugnayan sa sistema ng hustisya. Then number 3 is encourage of truth-telling. Nangangahulugan ito na ang paglikha ng kondisyon na tumutulong sa isang bata na sila ay makaramdam ng ligtas at iginagalang at ang kumpiyansa nila ay makapagsalita ng tapat tungkol sa kanilang mga karanasan nang walang takot at paggigipit o pagkalito. Thank you.
I'm Raven Barakyo, reporting the definition of terms. First, what is child witness in testimonial evidence of Rule 130? Child witness is any person under the age of 18 who is called to testify in any judicial proceeding. And also qualified din dito ang adults na may mental or physical disabilities. Next is the guardian ad litem. Guardian ad litem is a person appointed by the court to protect the best interest of the child during the proceeding and to assist the child witness in court. And most guardians ad litem ay ang attorney. Next is the support person. Support person is any individual, including a relative or friend of the child, who is allowed the court to provide emotional support to the child while testifying. And the last one naman is the facilitator. Si facilitator ay ang appointed by the court to pose questions to the child under direction of the court. The facilitator helps face or rephrase questions in child-friendly manner.
Gerald Alam reporting for coverage of the rule. The rule on examination of a child witness applies to criminal proceeding, child victims of or child witness in a case such as sexual abuse, physical abuse, trafficking, kidnapping, child abuse, etc. Civil proceeding where the testimony of a child is essential, e.g. custody battles, adoption cases, annulment cases where the child testimony is relevant. Special proceeding, any judicial inquiry where a minor testimony is deemed crucial. It is mandatory for courts to apply this rule when a child witness is involved. This ensure uniform standard across various courts and tribunals. Thank you.
Hello everyone, my name is Lance Valumero Tigro, and I'm reporting the appointment of the rule of the guardian ad litem appointment. The court may appoint of the guardian ad litem. So ibig sabihin ng guardian ad litem ay isang kumakatawan or ito talaga ng hukuman upang protektahan ng mga kabataan ng mga kapansanan habang dinidinig ang mga kaso. Moto Crosio on its own initiative or upon motion by any party it finds that the children need special protection and presentation of interest. And the GAL can be the attorney on a non-lawyer with relevant expertise or social work. Function and responsibilities. Protection of the children interest. So ito yung mga sinabi ko nga sa guardian ad litem na ito yung mga tao o mga katawan na pangprotekta sa mga kabataan o sa mga kapansanan, sa mga dinidinig pa yung mga kaso. So ensures that any legal strategies or decision of the consistent with the child welfare and emotional well-being. And ayun yung mga bagay na binibigay ng isang mga hukuman upang protektahan sila. Coordination. So works closely with the child counsel if separated to adopt measures and minimize the harm to the child. So yun naman yung mga binibigay ng mga consideration upang ma-focus sila kung nasaktan man sila or may mga kapansanan man sila or mga sakit. Ganun. So the participation in the court process may make recommendations to the court regarding the conduct of examination, protective orders, and other matters affects the child. So yun yung mga process or sa mga court na kung paano o naprotektahan ng mga or ang mga protektahan ng mga kumakatawan o mga itinalaga ng hukuman.
Joseph Vincent Cordero, reporting. Number 5. Courtroom environment and special measures. Child-sensitive courtroom. Court are encouraged to modify the settings to make it less intimidating. For instance, allow the child to bring comfort objects. Release courtroom attire or arrangement to avoid hostile atmospheres. The judge should ensure that child is made comfortable explaining basic proceeding in an age-approximately manner. 5.2 Support person. The role allow a support person, a trusted friends, relatives, or professional to be present beside the child during testimony. The support person should not prompt or influence the child's testimony but may provide emotional resonance. 5.3 Use a screen or videotape deposition. In sensitive case, the child may be allowed to testify outside the courtroom or behind the screen to avoid direct confrontation with the accused. Or closed circuit television or CCTV or similar electronic means can be used if the court deems it necessary to protect a child from trauma. Videotape disposition. The child's testimony might be taken in advance and presented in court, subject to cross-examination in the presence of counsels to reduce repeating in exposure to traumatizing environment.
Competency and OWAT taking. Presumption of competency. Under the rule, every child is presumed competent to testify unless the court determines otherwise based on clear and convincing evidence. The traditional requirement of proving a minor's competency by showing understanding of the obligation to tell the truth has been liberalized. Instead, the focus is on the child's ability to observe, recall, and communicate the facts. Sa madaling sabi, ang competency ay kakayahang ipakita ang iyong kaalaman, kasanayan at tamang asal sa pagtupad ng iyong propesyon o tungkulin. Halimbawa, sa isang propesyon, ang pagiging competent ay nangangahulugang alam mo ang mga batas, proseso at etikal na pamantayan ng iyong trabaho. Pinapakita rin dito na ikaw ay handa at may kakayahang gampanan ng iyong tungkulin ng mahusay at integridad. Next is OWAT or affirmation. The child witness need not give a standard OWAT if the court finds that the child cannot understand its nature due to age or developmental level. The judge or a facilitator may simply ask the child to promise to tell the truth in a manner the child understand. Ang OWAT taking daw ay isang formal na panunumpa ng katapatan at pananagutan sa pagtupad ng tungkulin bilang isang profesional. Layunin nito ay pakita ang katapatan at pananagutan sa propesyon o posisyong tinatanggap. Tanda ito na handa kang maging bahagi ng isang organisasyon o profesional na grupo.
I am Julius Abangalisa. I reported direct, cross, and redirect examination of child witness. First is child-friendly questioning. The questioning must be conducted in a manner that the child can comprehend, avoid use illegal jargon, complex question, or repetitive harassment and misleading interrogation. Leading question may be allowed during direct examination if they are necessary to develop the child testimony and do not unduly suggest answer. Next is role of the facilitator. The court may appoint a facilitator who will conduct the examination by asking the question proposed by counsels. The facilitator rephrases or simplifies the question in a non-suggestive, child-appropriate manner. The court supervised to ensure fairness and accuracy in the process. Next is cross-examination. The defense still retain the right to cross-examination, the child protection measure, and ensure the child is not traumatized. Suggest may limit or prohibit question that are repetitive, confusing, or harassing. Last is redirect examination. Counsel may conduct redirect to clarify or rebut matter raised by cross-examination. The same child-friendly approach and possible use of a facilitator apply. Next reporter po. I am Julius Abangalisa.
Good day everyone, my name is Ana Palagos. Today I will be discussing protective orders and confidentiality, which are important concepts in cases involving children, especially when it comes to protecting their privacy and welfare. We have the protective orders. A protective order is issued by the court to to safeguard the identity and privacy of a child involved in a legal cases. This means that the court can prohibit the publication or disclosure of any identifying information about the child, such as their name, their address, their school, or photos. In highly sensitive cases, such as those involving sexual offenses or abuse, the court can also take additional measures to protect the child's privacy. For example, the court may order a closed door or in-camera hearing where the public and unauthorized person are excluded from the courtroom. This ensures that only those directly involved in the case, like judge, lawyers, and necessary parties, are present. In short, protective orders serve as legal shield to prevent further emotional or psychological harm to the child caused by unnecessary exposure or publicity. Confidentiality of records. Next is the confidentiality of records. This refers to the protection of all documents, files, and recordings that contain the child's personal information, such as transcripts, affidavits, video disposition, or psychological evaluation. These records are not open to the public. Access is strictly limited only to certain individuals, such as the parties to the case, their legal counsel, the prosecutor, and other people whom the court finds necessary, like a guardian and or a social worker. The goal of confidentiality is to maintain the privacy and dignity of the child, even after the case is over. It prevents sensitive information from being misused, shared publicly, or used to harm the child's reputation. In both protective orders and confidentiality of records, vital legal mechanism designed to protect the child's identity, the privacy, and overall well-being during judicial proceedings. They remind us that while justice must be served, it should be never come at the cost of a child's safety and dignity. And that's all. Thank you.
Mayuga reporting. Number 9. Special provision on credibility. No disqualification by reason of immaturity. A child testimony should not be automatically discredited because of age or perceived inability to fully comprehend the events. The court must carefully consider developmental factors but remain open to the reliability of a child's version of events. The second one is special consideration of delayed reporting. Children often delay disclosure of abuse or sensitive experiences. The rules and jurisprudence recognize that delayed reporting does not necessarily negate credibility. The last is corroboration. While child testimony can stand on its own, if it is found credible, corroboration is still valuable. The court, however, must weigh each circumstance on a case-to-case basis.
Psychological and social support refers to the help given to people to improve their emotional well-being, mental health, and ability to interact positively with others, especially during stressful or difficult times. Pre-testimony counseling. Courts may allow or direct that the child receive counseling or psychological preparation before testifying. This aims to ease the child's anxiety and help them understand the judicial process. And the next one is post-testimony assistance. After testifying, the child may continue to receive counseling and or debriefing session if needed. The court encourages relevant agencies or social welfare office to coordinate such support.
Good day, Jake Laboga reporting. Section 11, sanction for non-compliance. If any party or council fails to adhere to these guidelines, including but not limited to engaging harassing conduct, asking improper questions, or disclosing confidential information, the court may impose appropriate remedies including citing offending party or council for contempt, imposing reasonable sanction, disallowing improper question. The section establishment the consequence for parties or lawyer who fail to follow the court's guideline if someone acts improperly, such as by asking harassing questions, revealing confidential information, or otherwise violating the rules. The court has the authority to take corrective action. Possible sanctions include contempt of court. The judge can formally reprimand or penalize the offender for disrespecting or disobeying court orders. Number 2, reasonable sanction. The court may impose fines, limit participation, or issue the other penalties deemed fair. Number 3, exclusive or evidence. Any question, testimony, or evidence obtained through improper conduct can be rejected or disallowed. In essence, these rules reinforce that all participants must act with professionalism and respect for confidentiality, and the violation can lead to serious legal consequence.
I'm Mersabi Ayushjan, and this is my report about interaction with other rules and laws. The rule on examination of child witness operates in conjunction with the rules of court, particularly Rule 130 on evidence and various special laws. Republic Act number 7610 on child abuse, and Republic Act number 9262 on violence against women and children, and Republic Act number 9208 on trafficking, among others. Yung tatlong pong batas na po ito ginawa upang magkaroon ng hustisya yung mga kababaihan, mga bata na below 18 years old na inaabuso, ginagamitan ng physical, or tulad nila naman sa trafficking, among others, na ginagamit yung pangalan nila upang magawa nila yung gusto nila sa taong gagawa nilang ng masama. Kaya ginawa po itong tatlong batas na ito para magkaroon ng proteksyon at hustisya at mabigyan ng katarungan yung pag-aabuso tulad ng sa kanilang dignidad. In case of conflict, the child's best interest is the controlling principles and the specific protective provision of the rules usually take precedence over general procedural and rules. Yan lang po.
Good day. This is Asildo Christian Paul reporting about Rule 13, Jurisprudence and Application. Philippine jurisprudence has consistently affirmed the importance of, number 1, protecting children from the trauma of testifying, particularly in child abuse and sexual offense cases, or pagprotekta dun sa mga bata sa pagte-testify, especially dun sa may mga child abuse cases and sexual offense mga cases. Number 2, allowing liberal admission of their testimonies subject to cross-examination with suitable safeguards to ensure reliability. Number 3, evaluating credibility by considering the child's demeanor, psychological factors, and any corroborative evidence, such as medical findings, documentary or physical evidence, testimonies of other witnesses. Next, examples of relevant Supreme Court rulings emphasize, number 1, the necessity of a child-friendly environment to prevent re-victimization. Number 2, the acceptance of child-specific protective measure as not violative of the constitutional rights of the accused, provided the essence of confrontation and cross-examination is retained. Number 3, recognition that delayed disclosure of abuse is often due to fear, guilt, or confusion, which does not automatically undermine a child's testimony. Yun lang. Salamat.
This is Arcelian Lumidaw, base crime 4th year. Practical consideration for legal practitioner. Ang number 1 is preparation of the child. Coordinates with social workers, psychologists, or child expert. Ang number 2, coordination with the guardians, or ito po yung tinatawag na GAL. Is appointed, collaborate closely to ensure the child's best interests and comprehensions. Ang number 3 is use of clear and simple language. Frame questions in a way the child will understand, avoid compound and tricky question. Number 4 is respect the child emotion states. Monitor for signs of distress or trauma. Request break when needed. Ensure all protective measures allowed under the rule and utilize if necessary. Ang number 5 is preservation of confidentiality. It refrain from disclosing personal details about the child to the public or media.
Magandang buhay, Kim Brian Gregorio reporting the conclusion on the rules on examination of child witness, na kung saan ito ay napakahalaga na batas para maprotektahan natin yung karapatan ng bata at maayos natin yung child-friendly na proseso para hindi sila ganun na matrauma habang nagbibigay ng testimony sa korte. So, kailangan natin palakasin yung loob ng bata para mas madali natin or mas madali ng bata rin na mabigay yung kanilang testimony sa korte. So ang ating korte, kailangan i-apply natin yung child-friendly na kung saan is madali at aayon dun sa bata mula dun sa panunumpa hanggang sa pagtatanong. Ang ating korte ay pwede rin magbigay ng protection sa bata. Pwedeng in a way of sa screen or mag-video para hindi direkta na ma-meet yung ating akusado. Hindi matatakot yung bata na magbigay ng kanyang saloobin or magbigay ng kanyang testimony sa korte. Kailangan din nating mabigyan ng proteksyon lalo na sa privacy ng bata. Ang pagiging lihim or confidential ay mahalaga upang mapanatili natin yung privacy ng bata. At lalo na yung ating hukom, abogado or yung guardian is mabigyan natin sila ng parang maparamdam natin na nakaguide tayo sa kanila para hindi sila makaramdam ng trauma habang nasa proseso ng pagtatestimony ng bata. Dahil ang ating mga bata is meron silang kakayahang magsabi lang ng totoo. Hindi pa nahuhubog sa kanila yung pagsasabi ng mga hindi totoo na makakatulong naman yun sa korte.